Hello and welcome to this week's episode of Cannabusiness Live. My name is Jennifer Domingue.
My name is Nicholas Galendez.
About how to protect yourself from liability when entering into the cannabis industry. However, before we dive into that, let's talk about the news.
So the news this week is going to be a little brief, a little bit of follow-ups on last week's news and a few newsworthy items that are worth mentioning a little bit. First off, the hemp licensing program, agricultural pilot program that Travis and I discussed last week is in kind of progress right now. If you were one of the lucky groups that got to schedule an appointment at the licensing event, those are ongoing now, so we're both excited to kind of see how that plays out. Have you had clients kind of reaching out to you asking about hemp licensing? Is there a lot of interest, you think?
There's been a lot of interest right now, I think, especially because it seems to be a significantly easier process than cannabis licensing. You fill out a couple of forms, you pay a much smaller application fee, and hopefully you get a license. So there's been a lot of interest in that right now, and that is for research purposes. So it's not actually under the new 2018 Farm Bill yet, but that process is well underway. So we hopefully will be seeing an industrial hemp market pretty soon in the near future in Michigan.
Very cool. So we'll keep you up to date on that. Kind of another follow-up to last week. The Court of Claims still has not issued its decision yet regarding temporary operators. If and when we do hear any news, we will kind of stop the program about liability and give you an update on that. So we're kind of, to be seen what the Court of Claims judge is going to rule as far as whether temporary operators can remain open. Other than that, just a few municipal updates. There's some lotteries in the future going on, or ones that were held today. Grand Rapids had a pretty beautiful system set up with different, without getting too much into it, influence areas based on point systems that they recently just held their lottery for. And I know both Jennifer and I were watching very intently on how that process was rolling out. So they're basically going to now schedule those applicants for planning commission hearings and to decide whether or not to issue licenses to those particular applicants. On the flip side, Traverse City is also having marijuana facility applications, which they ended up having to stop the application process during and kind of cut off application submissions. And actually, more recently, we found out that someone or a group of applicants was suing the city for its application process. It looks like to be seen what's going to happen with that as far as if the lottery will get to proceed, if certain applicants that were detrimented by that decision will get to be included in the lottery or not. So we'll have more details on that in the future. And then I think last but not least, the last board meeting was yesterday. So there will be now, starting I think 12:01 a.m. or p.m., whatever it is, on April 30th, will be the Marijuana Regulatory Agency. So now you will be submitting your application directly to the Marijuana Regulatory Agency. They'll be reviewing, processing the applications, handling deficiencies, and after that they will kind of filter that through to whoever the decision-making body or individual is within the Marijuana Regulatory Agency as opposed to the licensing board. And it's to be seen as well, a lot of uncertainty as kind of the norm in this industry. But it's to be seen how that will streamline the process a little bit more, having somebody who actually reviews your application, issuing the decision on it itself versus a neutral, independently appointed board of 5 people. To close off with that, though, I did want to commend the board. I know there's a lot of different criticisms of the board, but I think, they're volunteers. They were tasked with almost the impossible task of setting up a benchmark for applicants. It was a rocky process, not to place the blame on anyone, but definitely wanted to commend them and congratulate them on the job that they did with what they had to work with. So best of luck to them in the future, wherever they may be. And I think we're all excited for the new changes and how the regulatory agency is going to kind of adapt and move forward.
I couldn't have said it better myself. So now I think we'll dive back into liability, which I think is everybody's favorite topic, or maybe just attorneys' favorite topics. But the biggest thing you really need to think about with liability in the industry is liability is everywhere. It is when somebody walks into your provisioning center and they slip on the rug outside the door. It's when you send out a bad batch of product, or you mislabeled something and somebody gets hurt because of it. It's if you have creditors that are seeking payment. There's liability that they could sue you for, and then not only go after your business assets, but also your personal assets. And so we need to think about how we can protect your personal assets while still running the business in an efficient manner. I think this is probably something that a lot of our clients don't really think about ahead of time, but needs to be really discussed when they're trying to figure out what sort of business they want to create. Would you agree?
Mm-hmm. Yeah, I think too, a lot of people come to us and, you have a big picture idea. You want to be an applicant. You want to be pre-approved. Mm-hmm. You have to find out what property you want. You have to make sure it's properly zoned. You have to apply to that local community. You have to get local approval there. You have to get approved by the state. You have to do facility narratives. You have to do the floor plan, the building, the drawings. You have to do a lot of things that are more big picture, that while it might not be sexy to you or to the overall industry, to us as attorneys, I think this is a very sexy topic, almost sexier than compliance. But we think of protecting yourself from liability and creating your company in a way that kind of protects yourself now, and you'll be really appreciative that you did it in the future, not if, but when these things happen. You're going to be glad that you have these things shored up and all your ducks in a row, so that when the IRS audits you, so when you do have product recalls, when there are fighting between the members, or potentially down the line when you go public and some of the shareholders bring a lawsuit, you're going to look back at the game planning and all of the careful decision making that you did in the future, or sorry, at the beginning, back in the future. You're going to be looking at that and very thankful that you did so. Instead of wishing that you had and having your personal assets seized by the government or by your creditors, so on and so forth.
Right. So, Nick, if I was just to file for a license, say I want to be a provisioning center, and I just file for a license under my own name, and I don't do anything fancy, and I just say, Jennifer Domingue with Cannabis Legal Group wants to file for provisioning center. Am I protected? Can I do that? What does that look like?
So you can certainly do it, and I guess that would be considered an individual application. Keyword on individual. So even though you would be a license holder, you would potentially be running a business, the law would consider you to be a sole proprietor. So with that kind of characterization, you would be liable, and you would be kind of on the hook for any kind of potential problems down the line. Any lawsuits, they could directly attack your personal bank accounts, your personal primary residence. There just isn't that safety net that some of these other companies, some of these corporate forms end up allowing you to have freely, to promote certain business forms and corporate forms. There's kind of somewhat of an incentive, different tax rates based on these different companies that allow you to do that without risking your house, risking your life savings to a certain extent. And that's, I guess, where the limited liability phrase keeps coming up. There's limited liability companies, there's corporations. Those are the two most common that are end up being on there that people end up using. There's a plethora of other different types of business entities that you could potentially organize yourself as, whether you're not-for-profit, whether you want to be a partnership, limited, general. Leave that to us to kind of talk to you about more in depth, but certainly there's different ways and there's better ways to go about applying for especially a cannabis license, whether in Michigan, United States, Canada, than applying as a person that owns a license without any kind of business or corporate form as a safety net.
I would agree with that. So let's just kind of back up and think about big picture. What does limited liability really even mean? And so this is a question that is really kind of discussed a lot in the courtroom, and it's certainly discussed a lot when we're talking with our own clients. But limited liability just means that if there's a lawsuit against your company, it stops at the company level. So it doesn't protect the company's assets. They can still go after the company's funds, the company property. They can seek to collect on a judgment against your company, but they just can't transfer that obligation, that debt, that those bad actions onto you and force you to pay for it out of your own pocket. So this is something that is given as part of the LLC Act with the state of Michigan or other statutory laws within the state, where they all say, depending on which business entity you're forming, that you have limited liability. There's exceptions to that though. This is not impenetrable. Just because you file for an LLC or for a corporation does not mean that you've got a shield and it is ironclad and they are not going to be able to get through it. So there's a lot of different nuances to that I think we should probably talk about.
Mm-hmm. And also too, I know one of the common questions is, I want to be a corporation because I heard corporations are more protected,
mm-hmm.
or I want to be an S Corp. How do I decide that? What are the differences between that? Because I think too, a lot of times people bunch the two together. On the one hand, you have what kind of corporate structure do I want to adopt and run my business as? And then you have how do I want to actually have that business entity taxed? And those are two different types of questions, right?
Oh, that's very true. You can have an LLC that chooses just normal LLC partnership taxation, or they can have corporate taxation. You can have an LLC be designed to look almost identical to a corporation, where they have a board of directors and they're taxed as a corporation, but they're set up as an LLC. We can have a very simple and small corporation, or we can have a large publicly traded corporation. So it really kind of depends on your goals, and liability is something that you definitely want to consider throughout the entire business entity selection and formation, but it's the conversation with an attorney or with your teammates or your business partners on what your actual business goals are. That's really going to define how you structure this business, and then depending on how you structure that business, that's going to determine which laws you're protected under for your liability purposes.
Mm-hmm. Yeah. Okay, so let's kind of assume that we've taken your advice, and kind of the general practices is we've filed a company, we have actually done the corporate governance documents, mm-hmm. establishing how we're going to run the company, how it's going to be managed, certain different rules. So we're all set, we're good, we can do whatever we want? Or are there reasons why we should be worried, or things that we should be careful about in the future and as we continue to run our businesses? Because as I think you mentioned, this is limited liability, it doesn't mean complete liability. So there are certain situations where you can still have that safety net, but it can be pierced, so to say, or it can be completely removed, where you would still be liable for the debts, obligations of the company that you were doing business as.
Right. So the term is called piercing the corporate veil. This is a really fancy sounding phrase, but all it means is that if somebody's filing a lawsuit against your company and they're trying to get at you personally, behind the actual company, to get at your assets, they have to put forth an argument for the judge or whoever's making that decision on why they should pierce that corporate veil or that limited liability veil. The way the courts have interpreted this is very similar between LLCs and corporations, so I'm kind of going to lump them together for purposes of this Facebook Live. But there's really three elements. So think of it like chipping away at a brick wall between me and Nick, right? Like we've got this limited liability veil, and he's trying to get at my assets, and he just has to show three things. The first is that the entity is just a vehicle, a tool that I'm using for my own purposes. So something that you need to think about here is when you're creating your LLC or your corporation, you have to treat it like it's a formal business, because it is. If you don't treat it as a formal business, then they could say you're just using that business entity as like a shell, and it's just meant to protect you, and you're not supposed to do that. So what do I mean by you need to treat it like a formal business. You need to make sure that you're not commingling your funds, right?
Yeah,
commingling funds, yeah.
And I think too that, in legalese speak, that is something that we can kind of differentiate, but it's still a hard concept. If you think about it, corporate entities are a fictitious, made-up thing that we honor. And as such, if you own 100% of 3, 4, 5, 100 businesses, all of those things needed to be treated as separate. So if one property is owned by one company, you can't just pledge that asset on behalf of another company and expect that to be okay. And in practice, it might very well be okay. This is not intended as legal advice, but in the real world, it might as well be okay until something is wrong.
Right.
Until something goes wrong, and then a lawsuit's initiated, and they find out that not only have you been pledging that asset that one company owns to another company, but you're also transferring money from bank account to bank account without any legitimate purpose other than to shift money around. So that's what Jennifer was talking about as far as using those companies as a mere instrumentality, as separate different piggy banks in order to just try to set up as many safety nets as possible. So respecting the corporate form means treating each business separately, making sure all the dots are connected and ducks are in a row, so that if you have to take a distribution from one company and actually pay yourself because you're 100% owner, you do so appropriately. If you're going to capitalize that other business, you have to do that appropriately. And so it's all really about just respecting the fact that you're applying and creating these different kind of baskets or different companies, and they all have to be treated separately and follow their own rules and follow the law and the tax codes, so that you aren't found to be commingling your funds or treating these just kind of as a way to get around any kind of personal liability on your behalf.
Right. So that's the biggest thing in a nutshell right there, is that first element. You can't treat the business as just a protective shell. You have to actually respect the business. The second element is that there has to, that the business has to commit a fraud or has to do something wrong. So this person who's suing your business has to not only show that you're using almost like a sham of a business, or you're not respecting the business, but also that that business did something wrong. And that is usually fairly easy for them to prove, depending on how bad the issue is, really. But it really comes down to, how are you treating your own business? Was there a fraud? And then finally, was somebody hurt by this? Did somebody lose profits? Did somebody lose money? Did somebody get hurt? If they can show those three things, then the court could say, you don't have limited liability anymore, and now they're going to be able to come after you personally. So that's piercing the corporate veil, or the limited liability veil, in a nutshell. That being said, though, there's still other ways that the court could pierce the veil, or basically allow for personal liability. One is, if it's by law, I think there's a couple different laws that will allow for personal liability to attach, right? Mm-hmm.
Yeah, and so one of the ways you can do that is kind of by contract. So if if we wanted to start a business and we wanted to say, okay, the members of the company, if Jennifer and I owned it 50-50, we could say, hey, we agree as a company, as the members of that company, to be personally liable for the debts and obligations of the LLC or corporation. That's one way. Another way is just by operation of law, other than that agreement, would be, for unpaid unemployment taxes, for environmental contamination, and for wrongful distribution. So, we couldn't just set up an LLC because we wanted to dump radioactive waste in Lake Michigan and assume that we'd be fine with that. I think that's just kind of a no-brainer. We're not by law going to encourage that conduct by saying that if you do that, only your company can be sued, not your individual members. So there's a few kind of exceptions, and I think they're based on public policy, where we just don't want to allow businesses to do this. Now, obviously, I know that corporations and LLCs and a lot of companies are getting flack for just what they do as corporations, not necessarily in the cannabis business, but just generally, I think the bigger the corporation you are, the more evil you're perceived to be. But I think this really touches on the really, really bad acts that we don't want anyone to do, whether how little or small you are. Certain things like that, taking money when you're not supposed to, not paying taxes on the employees that you have, or any kind of distributions that go into a bucket that serves the society, and then certainly just ruining and hurting the environment to a certain extent. We just don't want to authorize that kind of conduct.
Right, right. And the other really big area where we attach personal liability is if a member or an owner, a director, an officer, if somebody in charge of that company is doing something in their official duties as the owner and it's hurting the company. So if they do something that is like negligence or fraud, then and they can prove that in a courtroom that there's been negligence or fraud, or that this member was acting outside the scope of his authority and he's hurting the company or he's hurting others because of that, then they could say, well, you know what, personal liability attaches to you. You can't go out and do a bad act and then say, oh, sorry, not my problem. I'm part of a limited liability company or a corporation, so you can't come after me. That, I think, is also another big public policy consideration where we don't want to necessarily reward bad actors for being bad actors.
Now, let me stop you for a second. So you said in their role as part of the company, and I think that in a lot of situations, if you're 100% owner, you can say, hey, other company, I want to enter into a contract with you. Here's my name, here's my proof of that I am who I say I am, and here's my name on the document that's being signed. But in certain other situations, you might be acting on behalf of the company. It might be implied that you are able to act on behalf of the company. So there's certain different types of authority that you can have, either express, implied, or apparent, that could bind the company and make it so that you are acting in your capacity as the member or manager of that company, and actually, objectively from the other side, somebody would reasonably be able to think that you're conducting business on behalf of this business. Obviously, in certain other situations, if I'm just, Nick as the individual entering into a contract, there's other situations where that's not the case, and it's clearly me, committing a tortious act or breaking a contract. But then there's other ones where maybe I go up to, a vendor booth in a Cannabis Legal Group jacket, and they might think I'm entering into the contract on behalf of the law firm, and they reasonably had, just beliefs that that was the case. And that's where there's certain, there's accountability on both sides, but I think as the actor entering into these things, that's where you need to be careful to actually, if you're having people as the owners do business on your behalf, you want to make sure they're acting within the scope of their authority, they're not overstepping bounds, and then certainly, negligence, fraud, tortious conduct is something that you want to be careful about.
Right. Now, keep in mind that there is going to be a presumption that you're doing things that are in the best interests of your company. So if you get sued and you're acting in the company's best interests, the court's going to be inclined to agree with that. There's that presumption that you are acting in your company's best interest by taking a certain action. They have to overcome that in order to have personal liability attached and make you personally responsible for any sort of damages. There's a couple of other smaller ways where personal liability could attach. The first is pretty obvious, but it's worth saying anyway. If you personally guarantee a loan or a line of credit or some form of contract for your business, and you're putting yourself out there as basically supporting the business and you're going to provide funds for them or something like that, then you're putting yourself in a position where you could be personally liable. They could attach personal liability to you. So that seems fairly obvious that if there's a creditor and you've personally guaranteed that line of credit or something, that you'll be personally liable, even though it's an LLC or a corporation who took out that loan in the first place. So that one's pretty basic. But another one that is a little bit more nuanced and people don't necessarily think about is if you are new to this industry and you get a license under your new LLC name, say it's ABC LLC, and you just got a license and you are licensed as ABC LLC. But that's a really boring name if you're going to be a provisioning center and you want to be called the best cannabis shop. And that's what you are going out and marketing yourself as, and you're entering into contracts and you're calling yourself the best cannabis shop. If that's what I said. I don't remember what I said. But anyway, that is your new name, and you're saying, this is my new company name, but you didn't file a DBA with the state, a doing business as. Now you have some problems because you are saying that your company, ABC LLC, is really this other company, but there's no legal basis for you to do that, and somebody sues the best cannabis shop, but there's no connection back to ABC LLC, now personal liability can attach. So you really want to make sure that you're getting a license that's awesome, you're going to set up your grow, you're going to do this, you're going to do that. That's all great, but you got to make sure that you cross your T's and dot your I's and you file all that paperwork with the state, because if you want to have a really cool name and it's not the same name that's got the license, you need to have that, or else you're completely eliminating that whole limited liability aspect of your company. And part of the reason why you want to get into the LLC Act in the first place.
Yeah, and I mean, it's like I mentioned, it's a fictitious thing that sets up an imaginary safety net. It's real to the extent that you are protected from a lot of things personally, even though your company might still be on the hook for it, but only if you submit that real paperwork that sets up that imaginary safety net, so to speak. So I don't know if that's all we needed to cover here, but I feel like that's pretty good for a Friday afternoon. As we mentioned, we like to poke fun that this isn't the sexiest of the topics, but I think both respecting the corporate form and having your corporate governance documents and really making sure that all your ducks are in a row, combined with a really good compliance program, because you need to actually follow the rules and not get fined and not get sanctioned in order to maintain your license. So on the one hand, you have your corporate form set up, you're protected personally, so you have a little bit of room to breathe there. You're respecting all of those formalities, you're running your business according to those documents that actually you set up very carefully to run your business. Right. And on the other hand, you have a good compliance program to actually make sure you're following all the rules and laws down to the T. I think those two sexy topics are really what people should think are sexy in order to actually survive in this industry. So if you don't have this, you could potentially get sued and have to go to bankruptcy because you didn't respect the corporate form. If you don't comply with all of the rules and regulations, you're going to get fined and cited and have your license taken away. So to us, to you, both of these topics should be very interesting, and if they're not, we can help you out with that and make sure that you're steered in the right direction. But other than that, I think we'll stay tuned until next week, and we can keep rolling with more interesting cannabis topics for you. Other than that, for Nick Galendez
and Jennifer Domingue.
Have a good weekend.